My name is Molly O'Brien, and I'm a fertility attorney practicing in the state of California. I started in this field working for an egg donor agency in 2004. Then I worked for a surrogacy agency for many years, and in 2011 I was admitted to the State Bar of California, and I've been practicing strictly in this field of law ever since. This video is about the process of obtaining a pre-birth order or a post-birth order, naming you as the only legally recognized parents of your child or children. The law that will govern your pre-birth or post-birth order will be determined by the state in which your surrogate resides. And every state has a different law with regards to surrogacy. So we have potentially 50 different laws that we need to be aware of. Each state can fall into one of three categories though. There will be states that have laws on the books, either through case law or statutory law. There will be some states that are silent as to surrogacy, but it's practiced there and can be done. And then there will be some states where it's simply not allowed and not practiced. Some states do not allow for a pre-birth order. They require that the orders be filed after the child has already been born. With all these different state laws to juggle, nobody can possibly expect the intended parents to know exactly what to do or how to do it. That is why it is crucial that you work with an attorney licensed in the state where your surrogate resides to help you get the best possible results. You should also speak to an attorney in your home country to ensure that you're complying with all of their laws and requirements as well. Since the laws are different in every state, it's probably easiest if I explain this in terms of California law, which is where I practice. In California, we have both statutory law and case law. The case law came many years ago, where surrogates and couples ended up going to court to fight over certain rights. And in each case, the court found in favor of the intended parents. So that helps to back up the rights of intended parents when filing these pre-birth orders. Then, in 2013, California passed a statutory law which specifically lays out the requirements for a successful surrogacy case. In California, the first step is to have a properly drafted surrogacy contract. It's very important that you retain a good lawyer who knows what the requirements are so that your contract complies with the law. The second step is once you're confirmed pregnant, some court paperwork will be drafted that will enable your names to go on the original birth certificate of the child or children. These will be declarations from the surrogate, declarations from you, from both your surrogate's attorney and your attorney, a declaration from the physician, and everybody will sign the same things saying that you are the only legally recognized parents, that the surrogate has no desire for parental rights or responsibilities, that you wish to have full custody and full responsibility, financial and otherwise, for any child or children born of this agreement. Once all of those documents are signed, they're then filed at the court. Now the court will take somewhere between 2, maybe 6, 8 weeks to sign that court order and get it back to us. The most important document in this whole set of documents is the judgment. This is the one that's signed by the judge, and it will set forth exactly how the hospital should fill out your birth certificates. Once your attorney obtains that order signed by the judge, they will send a copy to the hospital where your birth is going to occur so that the hospital is aware of the situation and can be prepared for your arrival. Another reason why it's very important to speak to an attorney in your home country is because you might need certain things done around this time. For example, you might need additional certified copies of that court order. You might need an apostille on the court order, or you might need assistance with passports. So it's very important that you discuss this with a local attorney. Keep in mind though, as I've already said, every state has a different law. So the way that it works in California, while it's very similar to how it works in other states, may not be exactly how it's working in the state where your surrogate resides. So be sure you speak to a local attorney in that state who can guide you through the process. For example, if your surrogate resides in a state where only a post-birth judgment is available, you definitely want to talk to local counsel about how to properly execute such a judgment. That's the basic process of obtaining a pre-birth or a post-birth order in your surrogacy journey.